Good afternoon, everyone, and welcome to the talk series at Serendipity Arts Festival. As many of you are aware, SAF is one of South Asia's largest multidisciplinary festivals that brings together performative, visual, and culinary practices from India and beyond. We are pleased to welcome you on a very important session today titled Protecting Creativity, Intellectual Property in the Live Arts. This discussion aims to explore the current landscape of intellectual property rights in the live arts sector in the context of India and globally, discussing the challenges and strategies to safeguard the creative outputs of theatre artists. This panel will be moderated by Shankar Venkateswaran, who is one of our theatre curators of this year. Shankar is the artistic director of Theatre Roots and Wings, an intercultural theatre company which he set up to function as a laboratory to develop the art of acting. He will be joined by Jean-Guy Lecca, a French scenographer and prominent figure in the world of theatre and stage design, renowned for his multifaceted contributions as a theatre architect, scenographer, technical director, and space designer. His career spans over 4 decades, during which he notably served as the scenographer for Peter Brook at the Théâtre du Boeuf d'Hainaut for more than 25 years. We are pleased to have with us Mallika Taneja, a theatre artist living and working in Delhi, India. Her most recent body of work, titled Do You Know This Song, for which she is both performer and artistic director, showcased at the current edition of Serendipity Arts Festival. We are also pleased to have with us Rafael Pereira, an intellectual property strategist working at the intersection of law and business at the forefront of technology, entertainment, arts and culture. He is the managing partner of Tinnuts, a progressive intellectual property law firm. Finally, we have a short video sent across by Christina Langer, Associate Legal Officer, Copyright Law Division of the World Intellectual Property Rights Organization, a United Nations agency in Geneva that promotes innovation and creativity through intellectual property. Over to you, Shankar.
Yeah, so maybe we could start with the video and then I can speak.
Good afternoon, and thank you very much for having me. My name is Christina Langer, and I work at the Copyright Law Division at WIPO. WIPO is the World Intellectual Property Organization, and we are an agency of the United Nations with a special focus in intellectual property. I work in the copyright and creative industry sector, and since a couple of years we do have a project dealing with copyright in theater and more broadly in the live arts. The work started a couple of years ago with a study, and in that study we focused on stage directors only. And what we wanted to find out is, what is the copyright protection for stage directors? How are they covered and what protection is provided worldwide? So we had this scoping study, which was not so much giving answers to many questions that arose, but gave us a good overview of the situation worldwide. And some of the main findings that this study gave us is that the situation is very diverse. There are some countries providing good coverage and good copyright protection, and then there are others where the situation is not very clear, where the law is not really precisely designed to mention, for example, stage directors. So we see a lot of legal uncertainty, and some copyright laws are just not up to date. Then also we saw that some countries have no protection whatsoever. So in those countries, unfortunately for now, we don't have any protection for stage directors. Following the study, we were wondering whether there might be other creators in the field of theater, or more broadly in the live arts, that perhaps face a similar situation to stage directors. So we enlarged the project scope to not only look at the stage directors, but also at choreographers, at set designers, costume designers, etc. And our purpose of this enlargement was to really see the situation in a broader sense. In order to do that, we created a questionnaire that we shared with professionals worldwide. And with that activity, we got on board Jean-Guy Leca, who's with you on the panel today. And he was a great help in drafting and designing the questionnaire and then also sharing it with professionals worldwide. We are lucky we received over 70 responses from people in over 40 countries. So this is a nice, let's say, snapshot of the current situation worldwide in order to understand what are the work realities and what is the work environment and also the legal situation with regard to copyright for creators in the live arts. Of course, the situation of some creators in one country might be very different to the situation in other countries, so comparing is a little difficult. However, the results that we received and the responses we have allow us to kind of draw some large trends. So, and I would like to mention a few of them just to give you an idea of what we found. First of all, we were asking about the work conditions very generally. So we asked, how happy are you with your situation? Is it good? Are you satisfied? Or are there maybe problems? And what we received back from the respondents is that around 1/3 of the professionals that answered the questionnaire told us that their situation is actually not good or even problematic. So that was already a first indicator that there seems to be an issue in the sector. We then kind of tried to see what are the concerns, and it turned out there are three main ones. The first one is the recognition as an artist. So many professionals complain or noted that they're not really considered as an artist and their creative work is not really recognized as such. So often they are just categorized as technicians or mere service providers instead of artists. A second point or second concern that was mentioned is the contract situation. So the way contracts are drafted, the contract negotiations, the bargaining powers, or simply the fact that in some countries there are no contracts at all. So it's merely like a handshake agreement, and there's nothing in writing that would confirm and define what is actually agreed upon. And the third big concern that the professionals told us about is the financial situation. So apparently in several countries, there's still the idea that working in the arts is more of a passion profession and not really something to earn money with. And in fact, from the professionals that responded to the questionnaire, around 1/3 told us that they're actually not able to make a living based on their creative work. This is, of course, difficult for young artists, for young creators who are just starting their career and who don't yet have a great reputation. So they're even struggling more with these challenges. And it is also a challenge in several countries where there are no associations or federations in the live art sector, meaning that the professionals are basically left alone, and whenever there's a challenge, they don't really have someone, an organization they could turn to and ask for guidance or support. We also asked about the legal situation. Of course, we as WIPO are very much interested in the copyright side and the copyright perspective. So we asked the professionals, do you enjoy copyright protection? How is it done? And here again, the result of the responses we received kind of confirmed what we already learned from the study regarding the stage directors. We see a very diverse situation around the world. The systems are very different, the approaches are very different, and also the scope of protection is very different from one country to another, and also between the different professions. So a choreographer might face different legal treatment than a set designer. Another point in this context is that the responses showed us that many professionals are not really aware of copyright. So even if they have copyright protection, they don't really know how to use it, how to exploit it, and what to do with it. So that was also an important point for us to learn and to see from the questionnaire. Following the questionnaire and these, let's say, larger issues that we could draw from the responses, we wanted to dive a bit deeper. And in order to do that, we invited a group of professionals to come to Geneva to sit down with our team and to just explain a bit more in detail and to give us their very practical on-the-ground feedback and experiences on the work conditions that they are facing. So we had this roundtable discussion in March this year, and Shanka and Jean-Guy were there, so they can tell you a bit more about these 2 very intense days of discussion. And what we were discussing with the professionals and what we were interested in was, on the one hand side, of course, the question of what are the challenges for you with regard to copyright? How do you use copyright? How is it organized in your country? How is it done? But on the other hand, we were also interested in the possible way forward. So we asked what could be strategies or maybe action points that we could do or that we could work on, maybe us as WIPO, maybe something that should come from the sector, from the live arts creators themselves. What could be done in order to improve the situation? So it was very interesting for us, very valuable insights that we gained, and we left the meeting with a list of proposals that we received from the professionals, where they were telling us what are the really priorities for them, what would be the points to tackle first. And this list is basically what we're working with right now in order to see what could actually be done, what could we do, what could we maybe collaborate with others. And we're already starting to pick some of these points that were mentioned there. For example, we're looking more into legal research to even better understand the copyright protection for live arts creators around the world. And we're also looking at the role of copyright management organizations, which are those entities that manage and administer copyright and related rights on behalf of creators. So we want to understand how they work in the live art sector and how they can support creators. So this is, of course, an ongoing process, but we started the discussion and we're very thankful for Shanka and his team that you're actually giving a platform for this topic at your festival and that you're having this panel discussion. Raising awareness, as we saw from the questionnaire, is an important point because apparently even the professionals who are kind of affected here don't really know about the situation. So thank you very much for supporting this and help to raise awareness in the sector and beyond. And I thank you very much for having me today to share a little bit on our work that we do at WIPO. And I wish you a very good discussion, very good insights and a fruitful discussion. And I thank you very much. Best regards from Geneva. Thank you.
Thank you, Christina. Thank you, everyone.
Thank you for coming. So may I now invite Jean-Guy Lacat, the legendary stage designer from France, who has transformed and created over 200 theaters around the world and has informed the spatial aesthetic of Peter Brook himself. Thank you, John. Please take your seat. Now may I invite Mallika Taneja. Mallika Taneja is a theater maker working from Delhi. When I received a mail from John about this questionnaire, the first person whom I got in touch with was Mallika to understand how she is dealing with this topic. And now may I welcome Mr. Rafael Pereira, who was suggested by Quasar Padamsee, because I couldn't find a lawyer working on this topic. So he was very quick to suggest this name. So quickly before we begin, I have a letter that Miss Sylvie Forbin from Geneva had sent us, which will give us a context. So
maybe you tell more about what is WIPO. I'm not sure that.
Yeah, WIPO, W-I-P-O, is the World Intellectual Properties Organization. It's a wing of the UN. Yeah, United Nations. And John championed and convinced WIPO and collaborated with them to have this brainstorming session, which happened in March for 2 days in Geneva. And I was also part of it. And when I got the mail, that's for the first time as a theater director, I realized that, wow, there are rights for me. Like, I did not know that like any of my work was protected. So how do you protect the rights of theater directors? And we made this questionnaire and answered those questions. And then there are some conclusions and actions, future actions. So I'll just quickly read out a little bit of this message that Sylvie Forbin has sent, which will give us a context. Yeah? So meeting summary, it was the meeting, the 2-day meeting, the summary of that. In the context of a deeper assessment of the situation of professionals in the live arts with regard to copyright as announced by the Secretariat during this particular meeting, the Copyright Law Division, CLD, organized a brainstorming session in the rights of live arts professionals. The meeting was held at WIPO headquarters on March 11th and 12th, 2024. The CLD invited 24 experts with different profiles representing various fields in the live arts, including stage directors, scenographers, choreographers, costume designers, theater directors, producers, and CMO representatives, as well as lawyers. Some professionals could not join in person and they intervened remotely. The geographical scope covered Argentina, Armenia, Brazil, Canada, Chile, China, Czech Republic, Egypt, India, Indonesia, Kenya, New Zealand, Poland, Romania, Russian Federation, Senegal, South Korea, Spain, Thailand, and the United States of America. Mr. Jean-Guy Lecat from France worked as a consultant with CLD in the preparation of the brainstorming session and acted as a moderator during the meeting. After the opening of the meeting and welcoming words by the Deputy Director General Sylvie Faubin, Mr. Lecat, the brainstorming session started with an introductory to the table, providing a high-level overview of the situation of the live arts in the representative countries. Professor Isolde Gendrau gave a summary of the main findings of the study on the rights of stage directors of theatrical productions, highlighting some of the main features of copyright in the live arts. CLD presented a synthesis of the findings of a questionnaire, which Christina just mentioned, which was sent prior to the brainstorming session to live arts professionals worldwide to gain an on-ground feedback on the legal conditions under which they work. Some outcomes of the questionnaires have showed the creators had difficulty making a living from live arts creations, and they attributed this difficult situation in part to issues related to contracts and contractual negotiations, recognition of artistic contributions, and legal uncertainty. They recognized a lack of awareness in the IP sector and noted that creators were missing support from their own professional networks, associations, or federations. Those issues were at the core of the discussion during the 2 days. The exchange confirmed discrepancies at the national level and with regard to copyright and related rights, including 1. What rights applies to live art creators? Copyright or related rights, non-existing or unclear legal provisions concerning live art creators. 2. A lack of support for creators through professional network, associations, or federations, as well as the need for CMOs for live arts creators in many countries. Uncertainty regarding the reuses of creations of the secondary exploitation and their secondary exploitations, especially in digital environments, as well as the regime of remuneration in the context. In a forward-looking discussion, the group identified the importance of raising international awareness about the situation, having some benchmarks for good practices in different countries, and benefiting from training activities in order to have tools when negotiating contracts or when protecting their creations in the case of infringements. The experts were very grateful for WIPO's initiatives on the topic. They regretted the limited existence of international structures that could represent them, such as an international federation for live arts. Based on the discussion, the brainstorming group proposed possible actions and initiative to address these issues and concerns raised. And this panel discussion is one of those initiatives at the Serendipity Arts Festival to talk about live arts situation in the country, internationally, and also a personal case study of Mallika's work. So we'll have John to give us an overview of his reflections on the topic, and then we will move to Mallika to understand her case studies, and then Raphael, as a lawyer and an expert, would enlighten us regarding the situation in India. Thank you, John. Thank you.
It appeared 3 years ago this important question of a copyright was completely ignored by the majority of the artists in live art. As Shankar said, with mainly theater, opera, dance, but it's also circus, street theater, and maybe other things we are going to create in the future. Who are creative people? The creative people are anyone who do something, and everything is doing is protect at the moment it start to do it. It doesn't have to do any official activity to be protected. Scenographer at the moment he start to make a sketch, not his idea, but his sketch, and the construction who follows the sketch will be protected automatically, forever. That means Shakespeare still protect. And maybe the English government can go to the court and say, you do not respect the text. That's possible. This is a moral protection. And then on the side, there is a financial questions. Most of the young people, when they sign the contract, they don't know what they sign. They don't read the contract. And there is some line, and the change of the money, you give your right, but you give your right for a certain period and a certain place. So, for instance, there is an opera, I work with the opera, and I signed that kind of contract, and I give my right, and I was paid back. But they redo it without to tell me. And then somebody tell me they are doing the opera, you should call to the opera, because this is not normal. So I called the opera, and the opera said, but you give a right. No, I give a right for when we create the opera. Now you do it a second time. You should give me another contract. And then we have a long discussion. I don't want to go to the court. It will cost more than what I can get from the opera, so I resign. But that exists always. At another level, there is a director in Switzerland who create a show, and that show in Zurich have a big success. A French director who was there copied the same show in Paris, the same set, same direction. So a friend of this Swiss director, by chance, was in Paris and tell him they are doing the same thing in Paris, and then they go to the court. And it was a very interesting question in the court. The judge asked the director, can you prove you are the director? And you cannot prove. How to prove? It was not film directing the actors. You have just a book with some advertisements inside. That doesn't prove anything. So there is many levels where the protection is important, because at the time we are copy everywhere, and especially on the line, on the internet. And the dance, for instance, I was in a theater last month on the balcony, on the mezzanine, and I can watch people, and at least 5 people film the whole show. So now with the telephone, we copy everywhere things, and then we mix different copy, and we are creative person, that's what the artificial intelligence is doing. It was a big demonstration and strike last year in America from a musician, because there is a real problem with the musician. The composers slowly are going to disappear. There is a machine who can make music. There is a machine who can create music. Will be the same for the set design. Last month, a friend of mine, the set designer, called me, and we have a talk. And at that moment, he stopped. He said, "One moment, because my daughter asked me a question." And then the daughter asked him to send a disc in a school, because from the artificial intelligence at home, she make a set by picking up things from everywhere, and And she put everything on the disk, and the father was supposed to send the disk to the school because the 3D machine is going to make the model during the night. That's the way young people are teaching in school now. So it's interesting because slowly the idea of to be a creative person is in danger. When I teach a student, I'm going to teach student in January again. They are not original. They pick up things, idea from outside because they think to be original, to be themselves is too difficult. And it's very easy to do it now with all the system. And I work with the architect for 1 week. They are so efficient on the computer. There is so many systems. You can glue things. The question of the art is really in danger behind that. But first, the artists, the existing artists are in danger. So we are in this festival. I hope I will be back next year in the festival, and I have the idea to make a sheet of paper, and I want to spread that to all the festival I know, and maybe here too, and then to have this sheet of paper everywhere there is a site, just to tell all the artists about their right, because they don't know. Most of the young people, they don't know they are protected. So we start with WIPO, with United Nations, to explore the question. I sent about 250 questionnaire, and the questionnaire was about 6 pages, something like that, in about 80 or more countries. 40 countries answer, and we have now more an idea about what's happened in a different country, because the idea of a copyright began at the end of 19th century in Switzerland, in Bern, and many countries signed to apply about this question of a copyright and have create a law to be in conform with that idea of a copyright of intellectual property all around the world. But there is now two systems. There is the American and the British system, which is when you are paid against your right, you give also your moral right. And it was, you remember, it was a lot of big scandal with a very famous director, film director, because the producer was able to cut part of the movie. Orson Welles, a big scandal with Orson Welles, one of the most famous film of Orson Welles, where the end was cut. There is a French movie 20 years ago where the tragic end of the film was changed in America by a happy end. So and the artist cannot do anything, because when you are paid, you give all your right. In England, it's more or less, in the Commonwealth, more or less the same. And the rest of the world is completely different. You are paid for a certain moment, you give your right for the creation of something, but the moral right belongs to you forever. So that's, so I want to inform all of the artists, they don't have to do anything to be protected, they are protected automatically.
John, would you also please talk about the space that you created for Avignon? And for the Avignon Festival, you created a space, and what happened to that?
Because
an artist.
Yeah, I transformed 200 space around the world. Some of space belong to be permanent, and that's something interesting, because there is many abandoned places here. You transform one, and then the authorities after maybe will destroy the building. Except when they realize, because you do a show inside, it's a beautiful place, and that might be one more theater in the city, and then they keep it forever. And this is the idea we have in the workshop we did this week. One of the project was to transform a car park, the middle of the car park, to the theater. Very easy to do. It's very simple to do, not very expensive. So there is many places all around the world now who exist from the time we were working with Peter Brook and play 1 month, 6 months somewhere. And Avignon Festival, for instance, we use a quarry. I transform a quarry as a theater. But they never tell me they are going to use now for 20 years. I don't want to have a copyright, but they could say I did it, so something like that. So it's a real question, because the artists need to be recognized. We are not artists to be recognized first, but if we are recognized and we can survive, we can eat from our work. So it's very important to copyright our respect.
Yeah, thank you, John. So when it comes to this live arts and questionnaire and working with WIPO, it was really eye-opening for me. Like how are lighting designers, how is their creative rights protected? Or costume designers. We credit them maybe, and after a while we forget them. Like I was talking to Mark from Korea, where he was talking about the Gangnam Style, that music video, the K-pop one. And it became a hit globally, but the choreographer who created that iconic dance was never credited or compensated for his work. So there are these kind of black holes that individual independent artists are trapped in. In the same way, when I got this questionnaire from you, John, the first person whom I got in touch with was Mallika, because Mallika was having a struggle, probably a fight with this theft of her intellectual property rights regarding her work, Be Careful, Thoda Dhyan Se. And Mallika Taneja is a soloist, and she works alone, creating something, very daring work, traveling around in smaller venues, but then the idea is too good, and then it gets stolen. So how, I would like to hear from you, more from you about this struggle and the ongoing struggle that you have to protect your rights, Mallika.
The story you tell us?
Yes, I shared this story at the WIPO, your story, because I wanted a case study to present a real story. Yeah.
Thank you, Shankar, for having me here on this very esteemed panel, I would say. Just to say, I'm going to think and talk, because I also have to watch how I speak about this on a public platform. You know why. I have, for the moment, this case is kind of resolved till it is not again. Therefore, one has to watch what one says. And actually, I was thinking exactly a year ago, I was in this quagmire and really very upset that I have been put through this this very difficult situation. And like what you said, I had no clue what my rights are. I had no clue who to talk to. I could see this is wrong, and I then didn't know what to do. So it actually gave me a lot of anger, because I had to now, with all of these things that we do, which is theater, which is difficult to do, it's a hustle to do the work that we do anyway. Now I have to look at this very big company coming to me and saying, hey, would you have a look at this and help us make this better? And when I look at it and say, I can't help you make this better, but I can tell you what you just did here. And I did. And I was, when I saw what they sent me, because they really approached me like this, and when I saw what they sent me, in my opinion, it was copying of my work. And I sought legal advice, and I sent them, my very first communication back to them was a very tightly worded 2-page letter saying, here is what I think. But it took time for me to get here, and it took time to understand what to do. It took time to really, actually it took time to accept that this is my fight, that this is also part of the work that I have to do to protect myself. And we also have to choose which fight we fight, and this was a very, very big company of a and a different form. This is video and stuff like that, with very different budgets involved and very different kind of eyeballs that it attracts. And I had 2-3 main problems. One was that clearly that this was theft of my idea. That was our claim. And I protect myself. When I do Be Careful, I protect myself. It is not an easy show to do. You know exactly how difficult that show is to do, especially in this country. And I've done it for 11 years. I've done it for 11 years without drawing too much attention to myself. So I've kept myself low key. I've kept myself in basements and this and that. We have to do this entire thing of keeping phones out, which was a strategy that you came up with at ITFOK, which I have then just continued. And while Be Careful is a very popular show, it's not a very popular show. It's a strange space it occupies. So everybody doesn't know about it, but everybody knows about it. It's a bit like that. And I felt like because you could relate back to me so easily, the association with me was so easy with what had been made, what I saw. I was like, this is a complete threat to my health and safety. This is going to give attention on me and my work in a way that I cannot handle. And I brought this up and I said, look, there is a way in which it feels like you're just putting a huge spotlight on me and leaving me in the dark, like to now deal with it because we've done this. And there were all of these things that went out. And when I accepted that this is, part of what I have to do, it is my fight, then we filed for mediation. It's a great tool actually in the high, and so we couldn't, there were all sorts of things because this is a very sensitive piece, because there's nudity in it. I was advised that it can't go in trial court, so it had to go in high court. There's a cost attached to it. So just putting it in would cost 2 lakhs. Just the filing was going to cost 2 lakh. And so we went for mediation. The mediation has failed. And now it is to be seen what happens. But I have to say that I'm very happy that I took the stand that I took once I realized that I can take the stand that I did, which means that there is, even though India is a very difficult place to navigate legally, but I'm also a legal being in this country. I'm not just a socio-political this, that. I'm also a legal being. I'm governed by a system, and there is a judiciary, and there are laws I follow. So if I can, and if I have the privilege to, I must knock at the door of the system that has been set up for me. So that way, I'm actually very, very happy that I did this. I don't know if I gave some sort of an overview. If you ask another question, I can answer with more detail.
Yeah. So could you briefly talk about the show, or would you let me just paraphrase a little bit about the show?
Please do.
And so that the sensitivity of the show we understand. So, thoda dhyan se, be careful. When the lights come, you see a woman naked. All she's having is a hairband around her arm. And then she stares at the audience, makes eye contact to everyone. And then there is two costume racks, cloth racks on either sides. And from there she starts to, as she's talking about the life of a woman in Delhi, and who has to take a particular bus to go from place A to place B. And so anytime, every time this woman steps out of the house, her father would say, "Beta, have fun, but be careful." So this "be careful" is a repeating sort of leitmotif that she hears as she grew up. And she talks about all this responsibility of what is being careful means, and etc., etc. Keeps on talking while she's pulling clothes from either sides, and she starts to dress herself like, underwears, like skirts, pajamas, like, continues to talk like, it's about responsibility. If one is not responsible for one's own responsibility, then who is responsible for the responsibility?
Oh, you remember the lines.
Exactly. Yeah, and then slowly this woman, like, this figure, it becomes like a haystack. Like it's becoming bigger and bigger and bigger and bigger and bigger with clothes. Yeah, she has mittens on now, she has socks on, she puts on everything, and the only thing that is left is a helmet. Yeah. And if I remember correctly the line, she says, like, I have to be careful because, if something does happen to me, at least I can say it's not my fault. And then she puts on the helmet and it's a blackout. So it's a 15-minute atom bomb of a theater piece. Now, this idea is what gets stolen or infringed. And the big challenge here, Raphael will tell us more about that. In the copyright laws, like, you have to, the idea or a concept is not protected. You have to fix it in a material form. Yeah, and theater is the most ephemeral of all art forms. So the fixation itself, it just dissolves. So then how do you sort of address that? This is a question. And for you, Mallika, like, could you like tell us a little bit more about the mediation process that you went through, and why did it fail?
I can't.
Yeah.
I cannot talk about the mediation,
Sure.
but I can tell you. So I send them this letter. They deny, and their claim is that nobody in their team has watched the play. And our claim is, that it doesn't actually, you don't need to have watched the play. It's a seminal work. You Google it, you find images, you find exactly these kind of descriptions in newspaper articles. I mean, it's everywhere. People who have worked with you have seen it, have heard about it, because they also had people from the theatre community who were working with them, because actually the entire thing was something to do with theatre. So there was all of these things that were pointing towards, I mean, come on. I mean, if you say, I didn't know, it's little bit difficult for me to believe, which is what we also wrote to them. That was our claim. And then, because there was this, we said, okay, fine, let's go to mediation. Because my ask of them was, please remove it. It's too much of a risk for me. Please remove it. But I have to say that eventually, I have it on record that what they showed me, they are not going to use. So the pushing back did do something. It did do something, that they have sort of told me that they are not going to use it. Now we have to see.
So before you are speaking, because you're specialized, we are not. I just want to add something to be clear, and you can understand exactly the context. Musician and writer are very well protected all around the world, because over them there is an organization, more or less international organization, who take care about this problem of copy. So, for instance, in France, there is people who organize a funeral, a company who organize a funeral, and then they use two music now for 20 years, and then they never pay. And now they have to give $1 million to the artists who make that music. They didn't know. Everybody thinks we can use a music like this without to pay the artist. The same in a wedding. The people organize a wedding, they make a party, it's public. At the moment it's public, you have to pay. So there is an organization who take care about that for the writers and the musician. but that not exist at all. And that's the first thing we were speaking about in Geneva. And now there is a new meeting in Geneva to see how can we build an organization. Because when you buy a ticket in a theater, about 2 or 3% of this money is going to that organization, to make that organization existing. So just to add this detail for you to understand the context.
Thank you, John. Now, Raphael, tell us the situation in India in relation to live arts.
Okay, I'm going to say everything Malika can't say.
That's great.
But I have to start out by saying thank you to everyone in this room for making time to be here. And I'm very angry with everyone else who isn't here. Because 2 days ago I was in this very room, on this very, on that chair, I was in that chair, speaking about intellectual property in music. And there were less than the amount of people there were in this room. And the people who were in the room asked, said, we don't know about our rights. And I get that maybe it's more of a priority to try and raise money or get more shows booked at other parts of a festival like this. But it's of no use if you don't know how to protect yourself or you don't know what rights you have at the end of the day. And I was hoping that Christina would be on this panel because I have a load of points now that are invalid that I wanted to give as feedback, that I wanted to give as personal opinion and some of my learnings. But maybe both of you can take it to her. It is absurd, absolutely absurd that WIPO is talking about protection in the live arts today, and that you have to do all the work that you're doing when we have the Berne Convention since 1886, was the first time this was discussed, and dramatic works are protected under the Berne Convention, right? In fact, the Berne Convention was revised in Paris, and further words were added to it to protect, to build on its legacy and further protect dramatic works and the authors of dramatic works. We have a huge text of a Copyright Act in India, where it's enough of a text that people have, you put 8 lawyers in a room, you'll get 12 opinions on the Copyright Act. That's how, that's how much it encompasses. In the music industry, we keep talking about, should we amend the copyright? Why? Because it's not about what's in the text, it's how people are interpreting it and choose to interpret it in their favor in order to not pay creators. So I'm going to start off very angry. It's inexcusable to me that, and I'm talking about this on a daily basis, and like you said earlier, you didn't know a lawyer, but earlier I was talking to Nandita, and Nandita's, I think, brother-in-law or brother is also an intellectual property lawyer. We're there. It's a problem that we have as well, which is we can't solicit work. I can't advertise to you and say I'm open for copyright cases, but I can tell you I'm a copyright lawyer, and that I'll be here 15 minutes after the session. But I can't tell you, please come to me with your problems. It's up to you to come to me with. But it's also like any other professional. If you wait till there's a problem, you've lost the case, right? So let's come down to and I'm speaking very generally, and I know, Malika, some of what I'm saying, you'll be thinking, I've done this and it's not working, or I'm doing this and it's the reality is something different from what you're saying, right? And I get that copyright as a subject matter, it's subjective in how it is expressed, it's subjective in how it's received, and it's subjective in how it's perceived as well. and the judges don't do any of the three. So, so if we, and I'm going to get cancelled from my profession at the end of this, so, but I'll do it anyway. With copyright in India, copyright protects literary works which are in, let's say, I'll speak in the context of the performing arts. Literary works are your script that you would have, a script writer, screenplay writer. We have an author in the audience. So the books that you write, the text that you write, the Copyright Office in India will recognize that anything more than a couple of sentences is protected as a literary work. Now, we have a musical work, which is composition, which doesn't necessarily have lyrics associated with it. So works of musical compositions are protected as musical works. Dramatic works, and mind you, this is not just India. I'm speaking at a global level, which is more than 100 countries, I believe, at this point, or at least 60 with a lot of uniformity. When you talk about a dramatic work, it is a work of movement, certain amount of stage directions, choreography, all of that forms a dramatic work. But India is also a common law country, like the UK. So one is the text that is written as the copyright law. The second is what we do with that text, how much we stretch it, how we set these principles of what does a dramatic work mean. Does the definition of 60 words in the Copyright Act, is that enough? Or does it apply to choreography, that is Mallika's stage direction that Shaw comes out with? Does it apply to the way a scene is lit? And I have a great example of the Manganiyar seduction, and I'll come to that. I'll come to that as well. Now, when we speak about dramatic works, literary works, and musical works, to a certain extent, artistic works, which would protect works of visual art. Let me ask all of you this, and let me ask WIPO this. What came first? The expression or the recording? Right? I think the expression came first, right? We were able to record much later. So how come the recordings are better protected than the expression? Right? And it was only when the printing press was created that we thought, okay, let's protect the copyright. Right? That is the right to make copies, and that's where it originates from, being able to make copies. Now, the rights of copyright holders before that, was still a problem. How would you, as an individual, let's say before there was the ability to fixate copyright in a particular medium, how would you enforce your copyright? Even, I'll give you the example of Samuel French coming into India. Samuel French came in, did a partnership with Jagriti Theatre, I believe in Bangalore. And what was their role and responsibility? Let's license our scripts to producers, to directors in India, and they will pay a simple royalty to, one, have copies of the scripts for rehearsals, two, be able to perform those plays in different theaters, and three, if they are going to record or do any sort of adaptation or change the script, translate it in any way, rename it, cut it down, elongate it, they would seek permission or pay a separate royalty towards that. I think it was less than 18 months, and Samuel French realized it's not going to work in India, and they left. Well, I'm trying hard to not be cynical, right? I'm past the angry phase now. Now, let me break it down for you. Also, coming back to WIPO. WIPO did the Beijing Treaty, which protects the rights of performers of audiovisual performers, right? Again, I ask you, what comes first, the performance or the recording? Right? The performance comes first. So, if we understand copyright in layers, because what you see is a finished. I mean, everyone says the cliche of copyright is a bundle of rights. I'll try and break down that bundle of rights for you. But what you see on stage in the performing arts, and let's say in theater and dance, is an amalgamation of literary works, musical works, and dramatic works, right? And when they come together, you can of course you'll say it is a dramatic work in its whole, but in India, each of these have separate copyrights. And copyright gives you a certain set of economic rights. That is the right to make copies, the right to distribute those copies, the right to adapt, translate, the right to fixate, right? The right to communicate the work to the public, and the right to publicly perform the work. And mind you, it's not just me in my legal language trying to tell you that the last two that I said are different. They're actually different. It's one to many versus one to one, but broadcast at the same time. So the difference between communicating the work to the public and public performance is what we're doing right now is public performance. But what that camera is recording and sending to all of you individually at home, that is communicating the work to the public. And these are subtle nuances that if you don't bother to take the time to understand, the law or judge is going to turn around at you and say, too bad, it's your loss. And well, at the end of the day, it is your loss. It is our loss. When and I know I may be rambling after a point, but I was also told to prepare some case laws and things like that, and I did write down those case laws. Although in law school I never did. I hated writing these case laws down there. It's the worst. Worst thing to mug up a case and then have to tell you which year it was, which high court, and what was the ratio. But since I did make the notes, I'll bore you with it. I think the Delhi High Court, interestingly, in a music-related case called Aditya Pandey, touched upon dramatic works and expanded its meaning a little bit. It wasn't the focus. It wasn't in the ratio of the case, but that's the most that we've touched upon it and expanded what dramatic work could mean. And they said it could include the stage directions. It could include the direction of movement, the entry and exit cues, and to a certain extent the lighting cues as well, right? When we speak about other cases, and again, we're a common law country, we need, if there is a dispute, although our judiciary has a huge backlog, we need courts to decide on certain matters so that there is a body of law to rely on. When it comes to dramatic works, it's a sorry state of affairs, because if you look at in the legal world, we have commentaries on the law to tell us if Article 21 of the Constitution has been violated. You'll have this fat a book, this tall and this fat a book, just on Article 21 of the Constitution. If I were to try and put together something on dramatic works, I don't think it'll be more than a couple of pages.
Paragraphs.
I don't. Let me put it this way: I don't think that work will be copyright eligible because there's hardly anything to put together and comment on. But I think you had asked me, or someone had asked me to talk about the Civic Chandran case. Now, the Civic Chandran case is good because it's evolved the law to a point where we understand what is the limit of fair use and fair dealing. In the US, you have fair use, but in India, we have fair dealing. Whereas in the US, fair use is a very broad doctrine which allows the court to define if a particular use is fair or not. Of course, there are certain principles, and there's a test that has evolved over a period of time to determine if a particular use is infringing or is it a fair use. In India, we have fair dealing, which Section 52 of the Copyright Act, that lists instances that are not infringement. So those are instances of fair dealing. Now, it's a lot more rigid, but I think in Civic Chandran, the whole point was to determine there was a piece of theatre and there was what they were calling counter drama. Now, even I had to read up and figure out what counter drama was, but essentially it was some sort of commentary to a certain extent, parody of the previous work. And to my surprise, the court held that this counter drama was transformative enough. It didn't use the entire text, but what it was doing was the creators of this counter drama, they were commenting on or expressing on this drama that already existed. So in that sense, it held that this counter drama was not an infringement, and in fact, it was eligible for copyright in its own right. So this brings me to a point also when we talk about copyright, it's and tell me if I'm rambling on too much. But when we speak about copyright, it's a legal monopoly, right? All of those economic rights that I spoke about earlier, they belong to you as the creator and you alone. But we also have, as individuals, at least in India and a host of other countries, you have the freedom of speech and expression. In most countries, it's about the balance between this legal monopoly of copyright and the freedom of expression. And that's why in a Civic Chandran case, there's also a case called the Chancellor Masters versus Narendra Publishing case in the Delhi High Court. And that's also something I want to talk about, Delhi High Court, a bit later. But in the Chancellor Masters case, again, the court acknowledged the transformative nature of the work. And therefore, it's not just infringement. The court is recognizing that you have transformed this copyright, and therefore this new work that you've created, it's not just about not being infringing. They're saying it has its own copyright, and copyright subsists in this new transformative work. I think with Manganiyar Seduction, they've had Royston has had a considerable amount of success touring that production across the country and across the world. But that comes at a certain cost. And for years, there have been rip-offs where I guess Royston has 20 plus boxes with light bulbs around it, and in each box there is a Manganyar who's performing. And for those who couldn't afford it or didn't want to pay for that experience, they would say, let's not do 20 boxes, we'll do probably 5, and we'll have 5 Manganyars, and we'll kind of create a similar sort of production. And it happened for years. Until one case in the Delhi High Court again, and unfortunately for copyright law, but fortunately for, I guess, Royston and the other party, the case was settled out of court. But it was settled on consensual terms, but there was a public apology given, right? And the infringers did acknowledge that they had created a copy of this work. And the court did pronounce its decree. And to me, what that means is the court recognized, or more importantly, the infringer recognized that just by changing the number of boxes on stage and just by putting less musicians, it didn't mean that they weren't infringing. So to your earlier statement of copyright won't protect concept and ideas, it has to be fixed. No, it doesn't have to be fixed. It has to be expressed. But yes, to protect, and it's protecting creativity, right? That's the session here. Unfortunately, each of you has to create a copy of your work and fix it, not to distribute it to the public, but like you said, Jean, earlier, to prove that you are the author of the work, to prove, and in your case, Malika, you mentioned, they claim that they didn't know the work existed. That's not an excuse. Copyright does not, that's not a defense to copyright infringement. The moment a work is created, if I am the first creator of that work, any work that is alike, that is substantially similar, that comes after, is an infringing work, no matter where it is, in which part of the world. Now we come to enforcement, and that's the challenge that we have in India, right? So here I would say it's important that you fix your work, record it, keep it fixed in time, because you need to prove that you were the first to create and everyone else is an infringer. I'm not even getting into the question of, are you the author of the work? I think that judge was quite bold in challenging, are you the author of the work? Could have been a strike in France the next day if the creative community wanted, but essentially, how do you prove that you were the first to create? And that is by fixing your work in a certain mode or medium. And today with the democratization of smartphones and cameras and video or audiovisual apparatus, I think even recording your first rehearsals or your final rehearsal before you go public, that goes a long way. And I have a few more points, but I think we'll come to it later.
Please, complete.
I think maybe let's also.
Actually, I want to speak about theatre as it is practiced in this country, and I think it has got a lot to do with how we are understanding so much about this. You said if you wait for the problem to come to you, you're too late. But the truth is, we are too busy doing everything that we are. I understand that we have to do A, B, C, D, E to protect ourselves, but that actually doesn't mean the problem is not going to come. The problem is still going to come, and I will still have to fight it. And I want to say that this is a very big case of big fish eating small fish. which is very much the case with me, which is very much the case with the 2-3 other cases that I got in touch with and I was put in touch with when I was doing this fight. The modus operandi is very simple. They copy. They do it. Then they get in touch with you and they say, oh, by the way, or somebody told us, or whatever, or you find out, like with Yashika Dutt, what happened. There are many layers to that case, but the truth is Yashika Dutt figured out that this is there because somebody who has read her book said that, hey, isn't this like your book? That's how Yashika Dutt made the connection. And then it's very multi-layered, I know that case, many things, but either somebody points you to it or they get in touch with you and it's simply too late, and then you're sitting with this huge, like burning coal in your lap and saying, okay, now what do I do with it? This is where I think that we have to recognize we are not small fish. That is where we have to recognize that there are systems. So please do advertise. Don't not advertise to us. Please advertise and say you are open to our cases, because one of the big problems for me was to figure who to go to, where to go, who to speak to. The other problem is that it's expensive. Theatre is poor. And how theatre happens, no? Theatre happens for years and years and years and years. We've borrowed, haven't we? Played this one's music, that one something. It's happened in this guerrilla way. Nobody has asked, and a lot of creativity was pushed because of this, because we played some song or something. So we don't actually think of our work or anything that we do as something that actually has any rights. Look at how theatre is in this country. What is its aukat? I want to know. Haisiyat, like what is its standard? Like what is its place? It is widely practiced. We say this all the time. Theatre exists in spite of the way theatre happens in this country. We speak to each other all the time saying, why do we do this? We come to festivals or whatever, we go anywhere. It is hard, it is expensive, it pays you nothing and you still do it. Now you slap a copyright case on top of this. How am I going to do it? I am not going to do it. I'm not going to do it, and that is the truth. Why was I able to do it? Because I had a little bit of saving and I decided I'm going to drown this money. This money is not going to come back to me. Of course, I've spent money. I've paid lawyer's fee. I've paid mediation fee. I've paid this. I've paid that. Whereas that company has a legal team. What do I have? I have me. But I have got to say, I'm also pretty enough. Yeah. I can also Google law. I can read, I have friends, I can call, please do it. But what is simply very, very lacking is a system of solidarity. It is true that there is a complete lack of support and solidarity. It is true that because there is this lack of solidarity, this absolute poverty in theatre, this absolute and complete lack of support, we don't read our contracts. Because we don't know how to read. I cannot tell you how many artists I've spoken to. I said, did you read the contract? No, we just signed and said. How can you sign a legal document which can actually, basis which you can be sued? How can you just sign it and say, humne kar diya? We just did it. Who will read, yeah? You will read. Who else is going to read, Read. And I think it's very important to know what we do. Firstly, we as citizens of this country are legal beings. That is very, very important to understand. Yes, it may not seem so, but we have rights and we must exercise them, especially if we find ourselves in some position of being able to raise voices. It's our duty to do it. And the second is that we have to have a system of solidarity. You have a legal case or you have any kind of trouble in which you have to lock horns with a system, you get to know who your friends are. Because how fast people disappear, or they stop taking your call, or they tell you I will find out and they don't find out. Very good time to know, like when you have to lock horns with any kind of system, who your friends are. But really, when you get to know who your friends are, hold on to them. Because we've got to, it is our fight. And who else is going to fight it but us? You know, in this huge time, there's so much content generation. People are starved for ideas. Yeah, if you're going to produce 50, 60, 80 series for one streaming platform, and then the other one is going to produce 50, 60, 80, there are 10 streaming platforms. Who the hell has the time to sit and think of an original idea? Like Jean-Guy said, it takes work to think, to really come up with an idea. So what are people going to do? Steal. And this is not the first time this has happened. Theatre, people have stolen all the time because of its ephemerality. It is very hard to say, this is mine, you know. Okay.
Thank you, to be brief. No, I just want to add something to you. I just come from Mexico, where I spent 2 months to direct a play from Garcia Lorca. I have to leave after the premiere, and the company probably film the production, and they maybe probably because they have an idea to do it again next year. It's easy to reproduce what I did from the video. Are they going to tell me something next year? Are they going to give me a royalty, something like that? How I can know? No way. I just want to add something about that problem of recording. In the past, when I began working in a theater, the TV came in the show to record some part of the show for the advertisement on the TV. They were supposed to record 3 minutes without to pay anything. That was something we organized between the theater and the TV. So they have a camera in the middle of the public, and they record the whole thing, of course. And we know that because there is a place where the TV store all the recording for the radio and the TV called INA. And INA, for 10 euro, you can be member of INA, and then you can have all the video from the last 70 years, you know. And there is a company who reproduced a play of Peter Brook from a text, from a Persian text, a Conference of the Bird. They take idea of Peter Brook from this recording who was done in the 70s. How can we control that? So normally, the video should be destroyed, but at the same time, it's a memory, which is good, because they prove what you did. So we have to organize that. It's not organized. The next thing is, you record. Everything in this festival are record. I didn't sign the permission you record, but most of the company, they sign, they accept to be record. What this recording will be in the future, where they are, who controls that? You know, there is a place where locked, a fridge locked, a box locked. No, you know, everybody can go to that. You know, it's a real question over this. To prove we have done the work, it's also a lot of possibility to copy your work. So on one hand, you cannot prove you do a work. On another hand, it's easy to copy you.
So firstly, I signed a contract that allows them to record me. So that's why I'm not objecting to it. But they give the lawyer the contract because I'm probably the one who'll raise the most objections. I don't think, forget about what I said in terms of lawyers or access to lawyers or educating yourself. Now I'm saying it, right, to everyone. Use your mobile phone and record your work. You don't need to, and the fact that you're recording your work, and record every stage of of your work. You have files, I'm sure you have lighting design files, you have session files, you have notes, you have your final draft pro that will show various stages of the work. All of that put together, I think, is enough to convince most educated judges, because we still have some uneducated ones, most educated judges that that you can the work is yours. And in now, mind you, doing this and educating yourself won't stop people from copying your work, right? That's not let's and to Malika's point, I mean, Jagrati Theatre had to end their partnership with Samuel French because the most common practice of people using their plays were they would just change the title, everything else would be the same. So even if I'm an infringement specialist, or I'm a crime detection specialist, I'm a police investigating officer, how would I know that my play is being performed, right? And this is the same question you asked me, and I'm qualifying it and asking it back to you. And I think Christina mentioned copyright management organizations. I think she should have said collective management organization. Yeah, collective management organization. Because copyright offices, copyright collection organizations, that let's set aside. The power and efficiency of collective management is what this is the answer and is the solidarity that Malika is speaking about, right? During the pandemic, just as the onset of the pandemic, I spoke to Q and Toral and everyone else, and I said, theatre in this country needs a copyright society or a collective management organization for dramatic works. That's the reason I'm on this panel, Shankar. Not because I'm an IP lawyer or anything else. It's because I reached out and I said, you need this. I don't need it. Theatre professionals in this country need a collective management organization, right? A CMO. Now, when, and even WIPO did a study on copyright offices in just before the pandemic, if I am right. They did a study on copyright offices around the world. But guess what? Copyright offices around the world are offices of record, not of fact. So even if you submit your entire work in a recorded form privately to the Copyright Office, and today I can submit with your name, I can submit a work of Shakespeare, and guess what? You'll get the copyright certificate. Why? Because it's an office of record. So they're checking the date on which it was submitted, and they're giving you a date and time stamp back. That's all it is. They're not offices of fact. And Shakespeare's in the public domain, right? We don't have and I've been fighting for this for a couple of years now. We don't have our works in the public domain well documented. So forget about people robbing your work. We have people who are robbing our traditional cultural expression and knowledge and claiming it as their own. So on the music side, you have CSAC in France. That's the global organization that protects author rights, and with their affiliate in India, and the Indian Performing Rights Society, IPRS, there are people who are registering folk songs in their own name. Those folk songs are in the public domain. There are people registering devotional songs that have been in the public domain for centuries now with their name on it. Does the Copyright Office know? No. How would you know? I mean, today we recommend our clients that they don't register their copyright with the Copyright Office. Why? Because the Copyright Office now is a copyright journal, which means if you submit your work into the Copyright Office, it goes on to their website and it's available for anyone to copy. right? So it is antithetical in its in the truest sense. But there are other ways of getting a time and date stamp, and WIPO launched something called WIPO Proof, which was a private kind of copyright registry. And a year later, they shut it down. So I think it's, if you're talking about solidarity and if you're talking about coming together, this is what is needed, because the SRAI, I believe, will announce in a short time that they are now a copyright society in India. The SRAI protects the right, their members are screenwriters and and I believe playwrights as well. They protect the rights of the authors of screenplay, authors of scripts for film. And for IPRS, the Indian Performing Rights Society, is 55 years old. But the screenplay writers or the screenwriters are just getting a copyright office made. India is the largest film producer in the world, and we have been for years, and we're now protecting the rights of screenwriters, right? But what does it take to submit this application? 5 rupees. 5 rupees to submit this application. What does it take to register an FIR for a copyright infringement? And mind you, you have that option in India. Nothing. Go to the police station, harass of course, takes your time, which is most valuable, but harass the police officer to register a FIR for a cognizable offense of copyright infringement. That is the only way you can fight a big fish in this country, because criminal cases trouble everyone, because an investigating officer will be required to call the director of that company that is infringing your work to the police station. The magistrate of the court will compel them to come to the court, and they will have to file either applications to not be present in person, and there are certain limits to which you can do that. So use the framework that we have. And when I'm saying, I'll go back to it, let's not forget, we've not overcome piracy through education in this country. We've overcome piracy through cheaper data being available. We're all the generation that would use Napster, LimeWire, and download and rip. And even today, let me ask any theater practitioner in the country, how do they legally get a copy of music and use it in their productions? And when we talk of equity and when we want a court to protect us, I think we all know we're not doing it right ourselves. So in courts of equity, we always say, if you're asking for justice, you come with clean hands. So whether you take the time to educate yourself or not, I think we know when we're doing something right or when we're doing it wrong. We can get into whether you have access to it and legal access to it later, but even if you don't have access, that's not an excuse to download a song or rip a song off of YouTube and use it in your production. That is still illegal, even if you pay an IPRS license. Right? So we have to take a step back, think about it. And if you are in the creative and cultural industries, not having time, not having the resources, I was just reminding Malika how I know her. I had this venue called the Mumbai Assembly in Mumbai, and I graduated law school, and I got into law school because it was the only degree I thought I could see myself doing. And but I wanted to be on stage. There weren't enough opportunities, but I saw people who were better than me on stage. Therefore, I thought I would be an enabler rather than a creator myself, and I took this position, and I chose to be here, enable creators. I can't advertise because I'll lose my license. It's not that I don't want to advertise. So it's not up to you or me, but it could be if 50 theater artists go outside the law minister's office and get them to change that, maybe I can. But when 50 lawyers try to do it, it's not worked in the past. So you have more power than me in this case. But yeah, I'll leave it at that.
We are really short over time, but really thank you so much for this wonderful discussion. Yeah. And I hope we are able to continue this conversation in the coming years, and really, like, it's about talking, putting it out, discussing, listening, sharing, that we can find a way to change things for the better. Yeah. Thank you so much.
The copyright was created to help creativity at the origin. But it doesn't work if we do not respect the right, and if we do not respect all the creative people are author. For instance, there is many countries, and France is one, where director, scenographer, light, costume design are technician. They are not author. So that's why we are working to push all the government all around the world to first, in the list, official list of the work, to put all of these people as creative people author. Otherwise, they have no right.
Yeah. So thank you so much. We wrap now. Thank you so much, Raphael. Thank you, Malika. Thank you, John. And thank you for all of you who stayed back and listened. Thank you so much.
So we have to take an appointment for doing the same thing next year.
Yes.
With a full audience.
Yes. Yeah, more people should know, more artists.
Slowly.
Thank you.